I'd like to welcome you to this webinar. So I'm Jonathan Tate from BTO Solicitors. We're based down in the central belt of Scotland. We have offices in Edinburgh, Glasgow and Helensburgh. I'm part of the BTO BeCreative team, where we look after the legal and business interests of the creative sector right across Scotland. So we represent artists, festivals, promoters, publishers, writers, authors, actors, you name it, we look after them, and we work very closely with XpoNorth. So we're really pleased that we can join in on this, and hopefully we can answer some of your legal queries and put your mind at a little bit of ease, which I know sometimes is difficult for a lawyer to do, but we'll try our best. And I'd like to introduce you here to Paul Motion.
Thanks, Johnny, and thanks to XpoNorth for letting me participate in the brave new world of Zoom webinars. I'm a solicitor at BTO, if I can keep my voice. Been a solicitor for longer than I care to remember, probably about 36 years. And as Johnny said, I have done various types of work, and that has included the creative sector, artist management companies, would-be superstars who didn't quite make it, but never mind, we'll not go there, intellectual property. And I'm hoping to talk to you today a wee bit about some of the questions that we've been asked. I have to say some of these questions would do justice to a law school exam. So if I ever find out who you are, I'll thank you and shake you warmly by the hand, but not in...
Although not at the moment.
not at the moment, no. Unlike our Prime Minister, I think he's finding that out as well. But anyway, we've got a list of questions that we've been sent, and what I'll do is I'll probably go through the first, I think, 3, Johnny, and then I'll maybe hand over to you. The ones that are quite legal, shall we say. So I'm reading them off my screen here, and I've got notes. So if I'm looking over here, I'm not ignoring you. I'm just trying to get my head around the question. So question number one. Question number one was, with the mass closure of small community-run live performance venues who maybe don't have contracts in writing, and quite a lot of them won't have contracts in writing, or indeed in any sort of recorded form, not even an email perhaps, what can you do? And I presume that question means what can you do in terms of perhaps getting paid or recovering any outlays, out-of-pocket expenses you've already incurred. In Scotland, you don't need to have writing to make a contract. That's been the law for many years. There are a few contracts where you do need writing. So if you're buying a property, or taking on a commercial lease, that has to be in writing. But other than that, verbal contracts in this country have always been perfectly acceptable. Now, I'm what they would call a solicitor advocate, so that means I spend a lot of my time in court trying to persuade a judge one way or the other. And if I was representing you, and you came to me saying, oh, I had a contract with this venue and they've broken it, what can I do? Say, right, got anything in writing? Sorry. So therefore we'll have to persuade the judge some other way. And there's no real magic about this. I mean, judges, for all that they get a bad press, are simply human beings at the end of the day, and they're open to being persuaded. So it's up to you and me as your representative to try and pull out some evidence that you did have a contract as you claim. And that can be anything, really. It could be discussions with the venue. It could be discussions you've had with your suppliers or hire companies. Anything that really builds a picture that persuades the decision maker that you did have a contract with this venue. And if you can persuade the court or the decision maker you've got a contract, that's you kind of past first base. The other sort of thing you can look at if you're trying to prove a contract that's not written down, depends on what kind of industry you're in. You can look at industry standard practice, and you can say to the judge, look, we did this, we did that, we did the next thing, and the other side did vice versa, and that's the behaviour of people in this industry who know that they've got a binding deal, and that will be acceptable to a court. So all is not lost, I think, if you don't have anything in writing. You should still have options to persuade the court there's a contract there. Now, at the moment, it's tricky because people are looking for refunds. I just clear my screen. People are obviously
I think this is probably really pertinent up, certainly in the Highlands and Islands, where I know, having talked to a lot of the venues and the venue managers, that there are no contracts in writing at all. It's all fag packet deals, as we sometimes call them, or you have such a historical relationship with a promoter or a venue manager, or somebody with access to a local village hall, that there are no formal contracts formed. So this is not something that is particularly new, and I think certainly as Paul was saying, this is stuff that we deal with quite a lot.
Yeah, I mean, I'll come on, that kind of leads on to the second question. I mean, I hope that's dealt with the first question. The first question was just, what can I do if I don't have a written contract? And I think the answer is, all is not lost, but you'll need to think about what other evidence you might be able to assemble. So the question wasn't about what are my remedies, and that will depend on each particular contract. But one thing that's been cropping up recently with coronavirus is how can we get out of contracts? And we've heard the words force majeure many times in the last few weeks. I don't know, one person has asked a question saying many contracts have got a force majeure clause. This will say that if either party to the contract can't perform it, then they're not liable. So is that right? Who's in breach of contract in this situation? So I suppose the first thing we better do is be clear of what these magic words force majeure actually mean. And basically, as I said, if you're unable to perform your part of the contract, just getting the wording up on my screen, which is refusing to maximize at the moment. There we go. Right, it will say something like, neither party is liable for any failure to perform or to make a delivery or whatever, which failure is caused by act of God, fire, flood, war, sabotage, or similar circumstances beyond the control of the other party. So a force majeure clause is really a sort of get to jail free, I suppose, is one way of looking at it. But of course, the starting position of any system of law is that we don't really like letting people out of their contracts. The court's instinct is always to try and keep people in the contract. If you have a court looking at your contract, you'll find pretty soon that the judge wants to try and make it work, doesn't really want to let people wriggle out. So as lawyers, we get involved in all sorts of concepts that we have to look at before people are allowed out of a contract. First and foremost, I suppose the easiest one, look at the wording. That's the starting point. What does the contract actually say? Does it cover the event that has just happened? And I can see that we're going to have a lot of litigation after coronavirus is over about the definition of force majeure, because when these clauses were drafted, nobody had ever heard of coronavirus. So there would have to be some other suitable wording that allowed you to get out of the contract because of a disease like coronavirus. So specific wording, that will be one of the first things we look at. then the other big question, I think, is given that the government has taken such a wide range of powers in relation to managing the coronavirus, and has ordered businesses, well, eventually ordered businesses to close. Didn't start off doing that, I don't think, but eventually ordered everyone to shut their pubs and hotels and whatever. Is that an event that would be covered by a force majeure clause? I would say probably, but there's never any guarantee with this area of the law. Other things we're going to look at are concepts like foreseeability. If you could have looked ahead and reasonably foreseen that something might be a problem to your contract, you might probably not be allowed to get out of the contract. Again, what you might find there is the court saying, well, has there ever been anything like coronavirus in the past? And then that would take you straight back to 2003 when we had the SARS outbreak. And the court will then say, well, okay, you had SARS in 2003, so the clause in your contract would have been written with that in mind, wouldn't it? So did you intend to be able to get out of the contract for something like SARS? As you can gather, this is going to be a pretty fruitful area of dispute for lawyers. And we're then going to have to look at the old standard concepts like causation. Was it actually the coronavirus that prevented you from performing the contract, or was it that you'd forgotten to hire the backline for the gig, or that some other non-excusable cause had been discovered? Some force majeure clauses that I've seen actually require performance to have been rendered completely impossible. So if all you're saying is, well, your gig's been cancelled, but it's going to be rearranged in 4 months' time, you might not get out of the contract, is what I'm saying there. Another concept that lawyers love to talk about is mitigation. Just because coronavirus has turned the world upside down, you are still, if you're trying to enforce a contract, to claim loss rather, you've still got a duty to mitigate your loss insofar as you can. You've got to take reasonable steps to show that you've avoided the effects of the force majeure event. Now, nobody really knows how that's going to work with coronavirus, but it doesn't alter the fact that in a dispute, there's going to be an argument over whether you've mitigated your loss, whether you've done everything possible to avoid the loss. And the other thing, I guess, is the simple one. If you're going to rely on a force majeure clause, is there something in the contract that says there's a particular way of giving notification that you are invoking the clause? And if there is, then you make sure that you have actually gone through that procedure. So where does that leave us in terms of consequences? If you can establish force majeure, you're excused usually from performance, or you might get an extension to things like deadlines or target dates. I guess the other consequence is who pays for any delay that's been caused if one party is told they don't have to perform the contract. Usually both parties end up paying their own costs, I would have to say. And then the third area to think about is that if force majeure allows you to delay performance and delay performance again, at what stage does it become too much so that the only option is to terminate the contract? I would say that although it's not a legal solution, it's a practical solution. Just try and keep dialogue going. Try and talk to the other party. Preferably don't ping emails or WhatsApp messages or don't totally do it by email or WhatsApp. Actually try do this, try and do a Zoom, or try and do something that's got face-to-face contact. And it's usually easier to negotiate an extension or come to some arrangement through discussion. Because if you get into a dispute, whether it's in a court or a mediation or an arbitration, you're going to end up having a discussion of some sort anyway. So better have it now than with lawyers involved 6 months down the track. I think, as we've discovered, I would like to think that people come out of coronavirus valuing their fellow humans a little bit more than they did before they went in at every level. So try a bit of discussion as opposed to standing on the terms of a contract. Right.
Can I just interrupt there for a second, Paul? If you see us looking away at phones that are buzzing, it's because we're getting more questions in. So we'll put them in as we go. So we're not being rude.
No, we're not. I'm getting 3 on chat. So we'll look.
So I've got one here. If you want to shall we interject here just now with some of the ones?
Yeah, just do that. Is this from Marie? Is it?
I don't know who this is from, but one that I've got through here from Alex, who's the head of XpoNorth. There is, I'm unpublished and unsigned, but have been offered a sync opportunity for an existing track. So we see that quite a lot. Should I have a lawyer look over this, and what should the payment look like, as that is the next phase? So should you get a lawyer to look over it? Yes, I think is the basic answer. We would always recommend that you have somebody that's either legally qualified or certainly with an understanding of sync licenses to look over these types of things. Sync licenses or sync deals can be quite convoluted, can be quite difficult to maneuver, and they can also be incredibly lucrative. So it's very, very important, I think, to get it right. Lawyers such as ourselves will look over these things. We will look over it with a pragmatic view, I would like to say, in terms of how we charge for these things. We deal with a lot of clients who are just starting out in the industry, so therefore we don't charge London fees. I'm quite happy to say we do a lot of fixed fees, but I would say certainly get somebody that's qualified or has a background in that type of thing to look over it. What it might say on the piece of paper, and again, this is something that we'll both talk about as we go through this chat, might not be actually what it means. And for peace of mind and for just your security, get it looked over. Anything you want to add there, Paul?
No, sound advice, right?
And this other one has come in. So I'm an independent artist and I'm working with a label services company. I've been signed before and they are offering the same services. Should I have a lawyer in place, or is this just a standard agreement? Well, going back to my previous point, I would always suggest that somebody looks over your agreements just to make sure that you're covered. There are standard agreements that are put in place. You can get standard agreements from various sources, the Musicians Union being one, for example. And, there are boilerplate clauses that transfer between these types of agreements, but there will be nuances from agreement to agreement. And I would always suggest that you get somebody to have a quick look over it.
I think I would agree with that. I mean, quite often what we find is not that's what's in the agreement that's the important part, it's what's not in it. So it's well worth having someone with a legal background look at your agreement. And it gives you a wee bit of credibility as well, I think, with whoever's offering you the contract. Just say, look at this. And they think, oh, okay.
And again, BTO BeCreative do these types of things, but you have other agencies as well, such as the Musicians Union, for those of you that are out there that have legal services that you're entitled to for part of your membership fee. So don't think this is just a sales pitch and come to us, but there are other people out there. But certainly for peace of mind and for, as Paul says, credibility for you as an artist, get it checked over. So that's the two that have come in via this handy thing. Do you want to go back to our script?
Okay, thanks. Yeah, I'm not getting questions. I've got one or two on the chat, but they're not questions. But anyway, if you get any more in, yeah, just we'll stop, just interject. Okay, the third question I got was about the e-portability regulation, which I'm sure you're all intimately familiar with. Question was, what happens after Brexit? After the transition period comes to an end? It's kind of a double whammy for the creative industries. And what should businesses be doing now to develop or clarify their copyright and to protect and enhance EU markets after the end of the transition period? We're creating work now, so should the copyright clauses in contracts reflect the future changes now? Right, where to start with this? Hands up who knows what the e-portability regulation is? Thought so. Okay, so e-portability regulation is to do with online content like video on demand streaming services, Netflix, Amazon Prime, that sort of thing. And kind of what it says is that as far as EU member state nationals, currently you and me, well, in the transition period, are concerned, they must be able to travel across the European Economic Area, which I think is the EU plus 2, isn't it? Anyway, they must be able to travel across the European Economic Area and access their online content services as if they were in their home state. And so that means that the likes of Netflix and Amazon Prime have to provide their customers with the same content in the home state as if they are, as when they're in, for example, France or Germany or Italy or wherever. But it only applies to travel between EEA member states. And because of Brexit, this requirement to make home state content available in other member states, that will vanish as of the 1st of January 2021. And that regulation will just be revoked. And so Amazon and Netflix will no longer be required to make UK content available in the EU to someone who's temporarily present in another country. So what's going to happen? Well, I guess the providers could agree just to continue doing what they're at the moment and make that content available. But if they do that, it seems to me they will need the permission of the owners of the content. At the moment, it's a legal requirement. After 1st January 2021, it won't be a legal requirement. So there will have to be, I guess, some changes in the agreement between the creators of the content and the streaming companies. So the contracts will have to be rewritten there. There'll need to be, I think, an option to, if the provider is going to provide this on a voluntary basis, then I think the content owners are going to have to sign up to that. And in relation to customers, people from the UK visiting the European Union countries, what they're going to see is a restriction. They're going to go abroad and they're going to be restricted as to what content they can stream in a way that they're not at the moment. And again, I foresee that towards the end of the year, there'll start being emails coming in with amended terms and conditions from Netflix and amended terms and conditions from Amazon. We're seeing that already, actually, just for your interest on the data protection front. At the moment, the likes of Facebook and Google are, as far as you and I are concerned in the UK, we're dealing with a company in Ireland. After the 31st of March, we will be dealing with a company in the USA for data protection purposes. And the same sort of thing will be happening towards the end of the year. So I guess the question was, what should businesses be doing now to develop or clarify their copyright? I mean, copyright, just to go back to basics, copyright comes into existence as soon as you write down the score for a song, or you create a picture, or you make a recording, the copyright arises as a matter of law in the UK. You don't need to do anything to become the copyright owner. So it's more a question of, I guess, when you're licensing your content, saying whether or not you want it to be treated as it currently is, or whether you want a more restrictive treatment. I don't know, Johnny, do you think there's anything else we can say about that?
Not really. I think it's one of these situations that, again, it's all a bit up in the air at the moment, really, isn't it? Like a lot of what we'll be talking about today. And sorry, I'm just looking at some other questions that are coming through. But yeah, it's as clear as mud at the moment, I think.
Yeah, I would agree with that. Are any of these questions ones that we can deal with just now, or do you want to just...
Yeah, well, there's a couple coming. So I run a studio space with business down. Any advice on dealing with my landlord in this unprecedented situation? The main advice I would give you, as I've given advice on this already this morning with the landlord, is to speak to your landlord. There might be provisions within your lease, perhaps not, that will deal with a specific situation. But I think everybody's aware of the financial situation a lot of people, and especially freelancers and those in the creative industries. And you will have seen that there's a moratorium being put on for evictions, so your landlord can't evict you for a 6-month period, and that is likely to be extended if the landlock that we're in at the moment continues. But certainly from a practical perspective, before you start looking at legal advice, a practical perspective would be talk to your landlord right now and see what is available. As I say, I've dealt with something just this morning where it's been agreed for an extended period of time that there will be a rent freeze, and that there will be a period of time for the tenant to catch up on those payments. So it's over a couple of year period. So it's not that you're getting away with the rent, but they want somebody in there. They don't want to have to try and advertise and market a property in this current climate, I would imagine. So speak to your landlord. If it gets to the point where your landlord is getting difficult about it, give us a call.
I'm just trying to look at the First Minister's statement to see whether that applies to commercial premises.
Yeah.
Because I know it applies to residential properties, but it just... I mean, the report I've got here just says no evictions for 6 months, but I'm just wondering whether that applies to commercial property.
Right. I thought that was across the board, but we can certainly check that. But
I'll check the small print. But I mean, I would have thought it was, commercially, unwise for landlords to be just, kicking tenants out. At this stage, if the rent's up to date, and even then, if you're not able to earn, the landlord must appreciate that that you're not able to pay the rent for a reason, but you'll resume once business picks up.
Yeah. And we're seeing quite a lot of our clients. I'm seeing quite a lot of family and friends in the creative industries that are going through very, very similar situations that you raised here. And for the most part, and I have to say it is for the most part, landlords have been very understanding. I myself am a landlord, and I have tenants that are based in the service industry who can no longer, are no longer able to work. So you have to take a pragmatic view of these things. Do you want your property sitting empty? Do you want your property? Do you want the job and the task of trying to market and infill a property in the current climate? Certainly for me, the answer is no. So speak to your landlord, and if that doesn't work, then give us a call. I've got one here. Oh, it's coming in thick and fast here. I split with my former manager, but have received a letter from his lawyer saying payments are being held for some work that I did. I'm a fairly experienced musician, but I've always had managers looking after my legal affairs. What's the smartest move? Well, I suppose that depends on what your contract with the manager was. I'm just saying, I don't know, what are the payments? Payments are being held for some work I did. you know, what are we talking about here? What is the work that you did? Was it releases? Was it live work? What, you know, but in terms of your smartest move, let us have a look at the lawyer's letter. We can give you some, you know, proper advice on that. But if you've had somebody always, you know, if you've had somebody always looking after your affairs, then that's fair enough. But I'm trying to think of situations where they would hold money back post contract. Can you think of any, Paul?
No, I was trying to look at this with the lawyer's hat on as well. I mean,
yeah.
What's starting point is what's the entitlement to receive the payment, and what does the contract say about holding it back?
Yeah.
Need to understand the basis on which payment can be held back.
Yeah. So you would have to look at your original agreement. So, you know, have a trawl back through that. It might be fairly black and white, as it were. You might be able to determine fairly easily, but if not, we can certainly have a look at it. I run a creative business and can no longer afford to pay the 2 staff that I employ. I've watched the recent government advice, but don't understand it in this context. Well, I don't think you're alone there. There has been a lot of conflicting advice coming, and certainly for self-employed people and freelance-based people. Paul, do you want to comment on that at all?
No, I think you need to talk to an employment lawyer, and that's neither of us, to be honest with you. I mean, the issue about whether you can furlough staff and the circumstances in which the government will pay. Put it this way, we've got our HR team and our chief executive trying to understand the advice at the moment, and I don't think I'll be giving a concluded view over a webinar. I'm sorry. Yeah. It's an evolving situation. The devil is going to be in the detail. And I think that's about all I would want to say, because it's not really my field.
So sorry that wasn't as concise as possible, but if you want to email us afterwards, we can certainly point you on to somebody that can give you proper employment-based advice, and I will give you the details on how to do that at the end of this.
Right.
Okay. I know measures have been announced for freelance creatives. With the delay, is there anything I can do? And I've not had an accountant. Well, again, as Paul has mentioned there, this is perhaps something that's it's very fluid, the advice that's been given. But again, give us an email afterwards, so we can give you more precise advice on that.
Can you just go over the question again, Johnny? Because obviously they're coming in thick and fast, and I didn't quite pick up all of it.
I know measures have been announced for freelance creatives. With the delay, is there anything I can do? And I've not had an accountant. So I think what we're saying there is there are some measures being put in place, financial measures, support-based packages. Perhaps what you're asking there is, are you entitled to it? Are you not entitled to it? So that depends on the makeup of your business. You know, there are certain criteria that you have to hit in order to get eligibility for these support packages. Government website is updating daily, but I will say that there are some great signposts for the freelance and creative sector, especially in Scotland. So have a look at Expo's site, have a look at Help Musicians UK, PRS, the Musicians Union as well. What they've done is they've taken a lot of the government advice and they've broken it down into concise fragments that are specifically tailored for the creative industries, and it's a lot easier to dissect. So, you know, signpost yourself there, have a look. But again, if there's specific queries and instances, perhaps email us directly after.
I mean, with this situation, you need to try and put together some sort of audit trail. I was reading this morning about some guy who'd used his redundancy money to set up an electrician's business, and he'd been trading for 8 months, and the cutoff for aid from the government is 12 months. So I'm not sure what he's going to do. Others are saying, well, you know, I'm a small business. I kind of live hand to mouth. I don't have much in the way of paperwork. You're going to have to try and construct a picture of your financial position as best you can, and maybe the accountant can give you advice. Maybe it's as simple as printing off, you know, bank statements and emails, but you're going to need some sort of evidence trail, audit trail before you get started.
I think certainly I had this discussion with somebody last night who is a a musician, a full-time musician, is a touring musician. So the majority of his work is in mainland Europe, and during the festival season, one of his recent business decisions is to go into is to take over a live music venue, which with a pub and restaurant attached to it. So all three sources of income gone overnight. And he's only been trading for less than 6 months in the new venture. So we were having a discussion last night about this, and that was exactly the point there. We, look at your audit trail, look at what your trading history to date is, look at what your expenditure is, look at what your income is. Your banks, we're finding that banks are being on the whole, and again I'll use that phrase of the whole, accommodating. So get your paperwork in place, get your audit trail done, speak to your bank, speak to your financial advisor. If you have an accountant, speak to them, they may be able to advise further. With a small festival organizer, it's looking likely that we won't be able to procedure this this year's event, should we be announcing it now. I suppose that depends when your event is, but if it's any time in the next 3 to 4 months, I would certainly suggest that an announcement is made on either postponement or cancellation. You want to give your audience, from a practical perspective, you want to give your audience as much notification as possible. They may be able to claw back some of their expenses. Leaving it to the last minute doesn't do anybody any favors, especially in these uncertain times. Some form of certainty is probably a godsend. It may also have implications on your insurance and some of your contractual obligations if you fail to announce something that is foreseen, if we go back to what Paul was talking about earlier, and you don't announce that in due course. Anything you want to add there, Paul?
Not really. I mean, in the current climate, I think the only advice we can give is with a view to mitigating your exposure, is probably err on the safe side. If you leave it till the very last minute when people have booked all their travel, all their accommodation, etc., it's just going to make life harder. So unfortunately, I'd say be taking the hard decision just now.
Yeah, so we've got another couple that have come in here, but I'm going to go back to the script just now, just so that we make sure that we've got enough covered, because I'm aware that we're over the halfway mark, and I don't want to run out of time. If we do run out of time, then Paul and I, I'm sure, will be available afterwards to answer some of your questions on email, okay, should you need. But if we go back to the script, so there was a question that came in when said when filming for TV, etc., what is the legal position regarding brands that might appear in the background rather than being featured, for example, signage, cans of drink, etc. So I think what we're talking about here is product placement or product displacement. And I'll talk briefly about this. So product placement is where the branded items are clearly visible. So your Coca-Cola cans, your Nike sneakers, whatever it may be. Product displacement is the opposite, where you might see it. You might see, for example, an Apple laptop, but with the Apple symbol on the back, stickered out or covered over in some way. So viewers know what the product is, and you see it in just about every television show with Apple products. You see the Apple cover on the back. The principle around this comes down to something called fair use, and that's something we'll visit on in a little second. But again, there are practical and legal implications on the use of these items. On one hand, producers don't necessarily want to be giving away free advertising to companies whose products are used in their TV shows or their films or music videos or whatever. However, some companies, and many companies actually, will allow the producers to use them for free because it's a very lucrative way from them to get free advertising. It may be the case that, if you're featuring a brand that is, for example, trademarked, there are rules and regulations about that. So there are some things that you can't have placed in television and films. I'm just looking at the script here. So there's legislation that covers this, the UK, the Communications Act and the Broadcasting Act. They brought about the Ofcom Broadcasting Code. So this is a list of do's and don'ts, and I can make the link available to you if that is so required. It's fascinating reading. I would recommend doing it last thing at night, especially if you suffer from insomnia. But there are broad principles which basically say, you know, that broadcasters must maintain some kind of editorial independence and control over the program that they're putting out, and you know, blatant placements will not be sort of tolerated. And they make a distinction here in the rules between what is, and I'll quote this, editorial content and advertising. So there is a distinction between the two. And it's obviously, the principle behind it is to protect audience from unscrupulous and surreptitious advertising. So it can happen. There can be a payment for it, or it can be done in kind, you know. And again, if anybody wants further information on it, then we can do. Paul, while I'm scrolling through these, do you want to perhaps answer question 4 about the people in the back of photographs and website shots and so forth?
I'm just trying to, before I do that, I'm just trying to get into the 1988 Copyright Act, because I'm pretty confident that there is an exception for incidental inclusion of branding in the background, but wonderfully the site doesn't seem to be working at the moment, so I'll try and get into it and come back to that one point if I may. I will come back to it before the end of the webinar. Okay, so do you want to go on to the next question, which was?
Yeah, so question 4 that we got on the script that we got in advance. So, using photos that are taken on a website or on promotional material, what is the position regarding people who might be in shot either specifically or accidentally? So this is something that we get asked quite often. First off, there's an important distinction between specifically including someone in a picture and having them accidentally in the background. So, for example, if you take a picture of Edinburgh Castle, you might find that there's lots of people in the background. Not today or any time in the next couple of weeks, obviously, but that would be a general sort of finding there. That's different from going up to Paul, who was on the promenade of Edinburgh Castle, and saying, "Oh, can I take your picture because, you know, you're wearing tartan or you've got a kilt on?" There's a hypothetical for you, Paul. Would you ever be seen in a kilt?
I've bungee jumped in a kilt.
There's an image for you.
There's video available with pixelation.
Oh dear, dear. So there's a couple of issues here. There's data protection issues, and there's also privacy issues. So I'm not going to go into a huge amount of detail because I'm aware of the time. But in essence, if you're taking pictures and somebody is in it, then there must be a lawful basis for you processing that personal data. Whoever's taking the recording or taking the picture, they're likely to be a data controller under Data Protection Act, so GDPR and Data Protection Act will apply. And there are requirements there for being able to use, and you must have a legal basis for processing that. So again, this is something that we've probably not got as much time as we thought we had to go into, but we can make available on the tail end of this.
Yeah, I think all you need to know about that is that if you're shooting footage in a public place and you're not doing it in an overly invasive, in-your-face way, then first of all, I'm not sure that the people in the background would have any sort of greater expectation of privacy that would outweigh your right just to take pictures in a public place. But even if you did need to justify sort of general footage of people in the background, I would say your legitimate interest in being able to create the footage would outweigh any rights they had as a data subject. It'd probably be good practice if you're shooting on location just to have maybe a couple of signs up to warn people you need to do that for CCTV anyway, so it's best practice to try and give some sort of notice to people. And likewise, if you're thinking of shooting footage at a gig or a concert or whatever, you could maybe add something onto the tickets when you send them out.
Yeah, yeah.
It's all about managing expectations of privacy.
Yeah. And again, fair use and fair notice. So another question that came in was, will the agreements between collection agencies such as PRS still stand after Brexit, or will they have to be renegotiated? Meaning that there could be a bigger delay in receiving payments. Well, the advice and the guidance that we got from PRS is that during the transition period of the UK leaving the EU, the same rules as previously applied will remain static, they will remain in place. Once we officially leave the EU, which, as Paul mentioned earlier, set for the 31st of December 2020, out by the 1st of Jan, those requirements and circumstances may change. The PRS, however, have urged people to be, I'm quoting here, have assured that the way they act on behalf of their members will not change during the transition period. However, the fact that it won't change during the period may imply that it will change after, but those changes have not been determined, and they've certainly not been communicated. So the advice there would be just to keep an eye on the PRS site. The PRS, especially in Scotland, are great. They're very forthcoming with information, and the head chap in Scotland and Northern Ireland is called Stuart Fleming, a very approachable chap, and I'm sure he would offer further guidance on this. He does workshops in and around Scotland all the time. Not at the moment, obviously, but I would urge you to keep an eye on the website or the PRS website, and attend one of those if you've got specific queries about how PRS are going to change after this. Another question is, what general legal advice would you suggest creative and cultural organisations follow at this time? Well, I suppose any actions that you take should be in line with current UK and Scottish government legislation and guidance. Now, as we've talked about throughout this webinar, guidance is changing at an incredible rate. But if you're planning on doing something or announcing something, then make sure that you are aware of what the current guidance is at that point. Any restrictions imposed by government will have implications for the performance of any contracts, I think as Paul mentioned earlier. And if it can be held that performing the contract may be contrary to public policy, then that might be your ground for not fulfilling the contract or getting out or having the contract delayed. And I think certainly yes. Keep an eye on the guidance that's given by the UK and the Scottish government. Another question that came in is, if you have lost business as a result of the coronavirus crisis, what kind of contracts can you have in place in the future to protect you for other major unforeseen devastating events? Well, you can have a myriad of contracts, insurance policies that cover business interruptions, loss of income. They're of great benefit. Paul talked earlier at quite some length about force majeure. You can have business liability insurance, which may, I certainly know that some of our clients have been are being covered by business liability insurance and business interruption for loss of earnings. So these are the kind of measures that you can put in place. You can insert certain things into the contract, but you can't foresee everything. So these types of policies and insurances are certainly worth considering. I'm aware that it's now just coming up to 10 to 2, and we've got some other questions that have come in on the text here. So I'll go through as many as I can at the moment. Paul, here's one. What's your general advice on basic property rights and brand protection for a host of online marketing courses I'm putting together?
Say again.
What's your general advice on basic property rights and brand protection rights for a host of online marketing courses I'm putting together? Well, I suppose you're looking at, your IP protection here.
Yeah, I mean, you basically IP protection. If you're creating the materials for the course, if you're writing the text or you're putting together the PowerPoints and the slides and the graphics, if it's you personally that's doing it, then you will own the copyright in all of that as a matter of law. If you have got a freelancer doing that for you, then you should have a contract with the freelancer. Otherwise, as a matter of law, they will own the copyright. If you've got an employee doing it for you, then you as the employer are protected because, again, the employer will own the copyright. So really, it's only if you're using freelancers or contractors, you should have something in their contract making it clear that any works they create belong to you. As I said earlier, this is not the United States. There's no means of registering or copyrighting anything in the United Kingdom. That expression just doesn't mean anything over here. It just happens as a matter of law. To protect anything that you've created, it's good practice to, at the bottom of each page, put a little C symbol with a circle around it and the date and the name of the person claiming the copyright. That always helps. In relation to other intellectual property, if it's a business, then you've probably got a business name. You might have a logo. Definitely worth thinking about registering either the name or the logo or both or in combination as a trademark. One of the reasons that it's very important to, I think, maybe give trademarks more recognition than they've had in the past is that we spend a lot of our time trying to get content taken off the likes of Facebook or Twitter or TikTok, and you would be surprised how little attention they pay to our carefully worded submissions until we say, and our client has a registered trademark, which is being infringed here. It doesn't work in every situation because on social media, we're just having a rant more often than not. But if they've set up a spoof site or a hate site with either your own logo or your business name or a variation of it, you're in a much stronger position if you've got a trademark. So worth thinking. Not expensive to register trademarks. We can do it. In fact, you can do it yourself online as well.
But the basic cost for registering a trademark is £170 to the Intellectual Property Office, and then it's a case of drafting properly, and that's where somebody like us would come in for a nominal fee. But as Paul said, you can do it yourself. It's not an expensive exercise, but it's certainly a worthwhile exercise. And if you have a registered trademark, it's a heck of a lot easier to stop somebody infringing upon your rights if you've got that. Copyright, as Paul said as well, it's sometimes a myriad of different bits of evidence to prove who had the copyright in the first instance. And the age-old, let's post it to yourself through the Royal Mail can be part of the evidential trail, but it's certainly not something that I would rely on as some other people would suggest. Where are we going now? Okay.
Can I just say one more thing about that? If you're collaborating, if you're creating something and you're collaborating, and I know that the question was one particular type of business, but that does recognise the concept of joint ownership of copyright. So if that's something like a musical script or musical score or a set of lyrics or a book or whatever, if you do that with one or more other people and the contribution that each of them is making is broadly the same, then as a matter of law they'll be joint authors, and one joint author can't deal with the copyright work without the permission of the other joint authors. So that's something to bear in mind, and you might want to have a wee email just dealing with copyright at the start. I mean, I know this is lawyer speak. It's the first thing that we think of, probably the last thing everybody else thinks of. But something in writing regulating copyright may save you a lot of anguish later on.
Definitely. Another one just on IP. I have a digital marketing company and have been contacted by another company regarding our branding. We haven't been we haven't ever been aware of this company, but our key artwork assets do have some similarity. What's our position, please? Well, it sounds as though they're claiming some kind of infringement or passing off here, in which case, you know, that can be a relatively, or it can be quite a serious matter. It's quite a serious claim. And I think that's one for perhaps you to email us about afterwards, so that we can have a little look and see if there's any merit to the claim. Quite happy to have a look over the letter as well. But yeah, it sounds as though that there's perhaps a claim for some kind of infringement there.
Yeah, we get a lot of these claims. People saying, you know, your logo looks like ours, or your brand name sounds the same as ours,
yeah,
or the color and get up and design of your product looks like ours. And there is no magic wand for dealing with these sorts of claims. Somebody has to spend the time sitting down and deciding, you know, whether there's anything in it. Initially at a high level, just a visual or oral level, and then have a look at the case law.
Yeah, and it doesn't say here whether the other company is also a digital marketing company. So if you have something like a trademark and somebody's claiming infringement of that, then the infringing, or the person claiming any infringement has to have some kind of like service or product. You know, you can't claim infringement or a similarity of a logo if, you know, for example, you're a digital marketing company and the company claiming infringement is a fish market. You know, there has to be some, you know, kind of confusion. And again, we won't go into too much detail there, but we do see a lot of these claims coming in, and they are relatively meritless, you know, on the basis. But again, we don't know that on the information provided, so quite happy to have a look at that afterwards. Now, I'm aware it's 4 minutes to, so we've got one last question.
Well, before you do that,
yep.
I mean, as I said in the introduction, I spend a lot of time in court. You promise a judge that you're going to come back to a point and then you don't do it. That black mark in your case presentation. And I said I would come back to you on that question of incidental inclusion of branding. Okay, I've now found what I was looking for. That's the joy of these live webinars. But anyway, so there's two aspects. One, if you take a picture or a video and there is someone else's logo in the background or a strap line, that would be a breach of copyright perhaps, but for Section 31 of the Copyright Act 1988, which says copyright is not infringed if you include in an artistic work, so that's a film or a broadcast, a work that is otherwise protected by copyright. So you should be okay on the copyright side. Simply in relation to taking a film and there's a glimpse in the background of a well-known trademarked logo, to me, that my argument on that would be you're not using the logo, therefore I don't think that would be an infringement. Okay, so I did say I would come back on that.
Okay, the last one, a very quick one. Any basic advice for online publishing as I'm aiming to release my first book? Do you want to do that, Bob? Any advice, any general advice?
For online publishing?
Yeah.
Well, I'll go back to what I said about copyright. Make sure that you have copyright over every conceivable part of it, even if it's watermarked. And just at the very front, there should be a very prominent assertion of copyright. It doesn't say whether the advice is in relation to selecting a publishing medium or. No,
I think it's just general advice. So again, you know, asserting your copyright. You know, make sure that you're aware of what the online publisher's obligations are and your obligations are. Make sure that you're aware of what their accounting obligations are, so what royalties you will get for what numbers. And, you know, we've seen a few sneaky ones that, you know, because some of the remuneration you get from online publishing is relatively small and you've got to hit a certain amount of units. I have seen some online publishers that will make you have £1,000 in the bank before they will release any funds to you, or £1,000 in sales before they will release any funds to you. So quite high amounts if you're looking at, you know, 0.2 pence per saleable unit.
Yeah, so I mean, the thing is, you need to read the contract they're offering you as well.
Yeah.
I mean, does it have an obligation for them to release your work? If so, is that just in one territory? Is it around the world? Are they wanting you to assign the copyright in the work to them so that they can deal with it?
Is it exclusive?
Yeah, is it exclusive? Is there the equivalent of an out of print clause, so that if the book isn't, you know, the work, heaven forbid, is not selling, you get the copyright back? There's a lot of things you need to look at public publishing contracts. And again, the easiest thing is maybe just to ping a copy of what you're being offered and we'll have a quick look at it for you.
Okay, so we've got 1 minute to go. So I would just like to say thank you very much to everybody who has joined in on this, everybody that submitted questions in advance, and everybody that's submitted questions ongoing. Hopefully we've answered your questions and queries sufficiently unmurkily, as lawyers do. But I would like to leave by just giving you a couple of signposts in these times. So there are some organisations that are putting out excellent work for support in the creative services, including Highlands and Islands, XpoNorth, Help Musicians UK, as I mentioned earlier on, the PRS. Creative Scotland have a lot of information available on their website at the moment. The Musicians Union are a fantastic resource. Look at the Touring Network and also look at Music Venues Trust. These people are all there to help and support, and they're lobbying, a lot of these people are lobbying on behalf of the creative sector and the freelance sector. So they are the first to know about information, and again, to a point I made earlier, they can dissect a lot of the information and the guidance that's coming through to make it pertinent to the creative sector. So go to these places. If you want any further information on any of the questions that we've answered today, or if you have anything that has popped into your mind and we've not been able to get to it, then you can contact myself on jta@bto.co.uk or
PRM@bto.co.uk, or follow us on Twitter @BTO BeCreative.
Thank you very much for your time. I hope it's been invaluable, and we will hopefully see you at some point soon.
Yeah, thank you all.